IICRA is an international independent non-profit organization which was established in 2005 under an international convention to be one of the infrastructure's institutions of the Islamic economy. IICRA's objective is to enable all dealers of Islamic economy from the Islamic financial institutions, clients and other entities to settle disputes of all kinds of financial, commercial, banking, investment and real estate issues through institutional reconciliation and arbitration in IICRA. The essential features of alternative dispute resolution in IICRA. Specialization and professionalism. IICRA is a specialized global platform for settling disputes with institutional reconciliation and arbitration with compliance of Sharia law. IICRA rules apply the best practices and standards which is internationally adopted in settling disputes with the support of our well-known arbitrators and experts in the field of Islamic financial industry with different official languages. Efficiency. IICRA imposes fixed timeframes for control of the arbitration procedures. This is to grant all parties the required procedures and required timeframes for raising their arguments and pleadings. The average time for settling of disputes referred to IICRA up to the end of the first half of 2018 was 126 working days, approximately 4 months. Flexibility. In parallel with the professionalism and efficiency in settling disputes, IICRA rules guarantee the parties with flexibility to nominate the arbitration procedures themselves, such as the choice of complementary procedural law, venue of the proceedings, language and other matters that may be agreed upon in order to strengthen the principle of the will of the parties. Confidentiality. IICRA guarantees privacy and safeguards all information relating to cases, which will be disclosed only to those who are involved. Integrity. Binding awards. The binding awards referred by IICRA are final and may not be susceptible of cassation, and with the acceptable international adopted mechanism to enforce the awards. IICRA applies the necessary mechanisms for auditing and reviewing the award with compliance of the provisions and rules of Islamic Sharia. Non-profitability. The control arbitration costs of any disputes include the arbitrator's fees and administration fees of IICRA, and these fees shall not exceed 2% of the value of the claim, and this will determine the fixed amount as a ceiling for the arbitration expenses. IICRA is currently working on activating electronic arbitration according to its rules and regulations to limit any additional expenses. Internationality and independence. By the value of international convention, IICRA was established as an international institution on April 5, 2005. The efforts of several international institutions concerned with supporting the Islamic financial industry to establish IICRA and the formation of its administrative structures along the lines of international organizations have been combined and given the necessary independence to carry out its mission. Multifunctional. IICRA provides all disputes resolution services in one stop, starting with institutional conciliation, institutional arbitration, appointment of experts and specialists, auditing and reviewing the awards from Sharia and legal aspects. IICRA provides additional support services to the Islamic financial industry, such as training and rehabilitation specialization in the legal and technical aspects of the Islamic financial industry. IICRA assists in the preparation of relevant draft laws, supports the plans to shift from the conventional banking to the Islamic financial banking, and IICRA also assists in the preparation of standard contracts for Islamic financial transactions. Therefore, IICRA has become one of the most important infrastructure institutions of the Islamic financial industry, and its legal arm presents the ideal specialized international platform for settlement of financial, commercial, banking, investment and real estate disputes with compliance of the Sharia law through mutual conciliation and arbitration in accordance with the best practices and standards which is approved internationally. Ladies and gentlemen, the International Islamic Center for Reconciliation and Arbitration advises the parties who wish to settle their disputes under IICRA rules to include the following arbitration clause to their agreements and contracts. If any dispute arises between the parties of the formation, performance, interpretation, nullification, termination, or invalidation of the agreement, contract, or arising therefore or related thereto, the dispute shall be referred to an arbitration panel constituted from uneven of arbitrators for a final and binding decision in accordance with the rules of the International Islamic Center for Reconciliation and Arbitration and its amendments. In respect of the dispute that has arisen without inserting IICRA's arbitration clause, the party should sign the arbitration agreement, which should be drafted by the IICRA after reviewing the parties' submissions and dispute details. For more information about IICRA services and to submit the membership application, please contact us on the following telephone number 971 4 294 9292 or by fax 971 4 295 9540 or visit us at the website www.icra.com.